so I don't have to, sounds like it's sliding. I don't have to walk around and hold my phone anymore. All right, so this week I'm going to talk a little bit more about the court system with a focus on litigation, and then get into some forms of alternative dispute resolution. So ways that we might resolve a lawsuit or resolve a dispute other than going to court. Or if we're going to court, ways that we can resolve our lawsuit without having to go through the whole expense and event of having a trial. So back to the court system for a second. Last week we talked about generally how they're set up, that we have a state court, that each state has their own court system, and that the federal courts have their own court system as well. We talked about how a case might be brought only in the federal court system or only in a state court system, or sometimes the case could be brought in both. We talked broadly about how we have our court system divided up into trial courts and appellate courts, and what goes on at a trial court versus what goes on at an appellate court. And so I want to talk about a couple more sort of general ideas before we get into a little deeper about litigation. The first one is about jurisdiction. So one of the foundational principles of our legal system is that in order for a court to make a decision or give an award or a verdict over someone, it's got to have jurisdiction over that person. All right. I have a fundamental constitutional right to be sued where I live in Georgia. If I get into an automobile accident this morning before class and I run into somebody who is, let's say it's a military guy, and that person is a resident of California, and the accident is my fault, that soldier can't go back to California and sue me over the auto accident in California. We have a right to be sued where we live, the state that we live in, generally speaking. So a lot of what you're going to find out in this class is we're going to talk about general rules first, and then we're going to go into all the exceptions or ways in which that is different. So yes, we do have the right to be sued where we live, unless we've done something in another state or another jurisdiction that is the subject of the lawsuit. So if we flip around my example from this morning, let's say that I'm in California and I rear end a California resident, then that California resident could sue me in California over the accident. That's called long-arm jurisdiction. So a state can exercise personal jurisdiction over somebody who's a resident of another state so long as the lawsuit has to do with the person's presence or activity in that state. I'm going to give you some examples, so we'll walk through it a little bit. But that's the idea of long-arm jurisdiction. Again, general rule is you have the right to be sued where you live. An exception to that is when long-arm jurisdiction exists, and you could be sued in a state other than your residence, but the lawsuit has to be over something that you did there. Business you conducted there, your physical presence there, that kind of thing. So at the bottom of page 1 of our outline for this week, you'll see that it's sort of a sliding scale. The more contact you have with another state, the more likely it is that you would be subject to being sued there, to jurisdiction in that state. We're starting off on the low end of the scale first. First example, a non-resident has no contact with Georgia whatsoever. Unlikely that that person could be sued here. The example is Jake lives in Alaska. He's never been to Georgia. He doesn't do business with anybody in Georgia. He has no contacts at all with Georgia. Not likely that he can be sued here. But what if he has a few contacts? What if Jake lives in Alaska? He's never been to Georgia, doesn't do business with anybody in Georgia, but during Christmas vacation, he flew through the Atlanta airport. And while he was in the Atlanta airport, he assaulted another passenger. Got on his plane, flew to Florida. Spent a total of 1 hour in his whole life in Georgia. Could he be sued in Georgia over the assault? Yes. Because the nature of his contact with Georgia are directly related to the lawsuit. The lawsuit involves his conduct in Georgia, his actions while he was present. Now, could Jake be sued in Georgia over a business contract that he has with a fellow Alaska resident? Probably not. His contact in Georgia was limited to just that hour he spent in the airport. So the lawsuit is going to have to relate to his time here, if that's all the contact he has with Georgia. Let's say that he lives in Alaska, has never been to Georgia, doesn't do business in Georgia, but spent a week here at St. Simon's at the beach over Christmas. He probably can be sued in Georgia. Georgia could use long-arm jurisdiction over him so long as that lawsuit is related to whatever he did while he was here. Maybe he and his friends trashed the condo that they rented and the property management company wants to sue them for damages. He would be subject to jurisdiction in Georgia because the lawsuit involves conduct in Georgia. If we continue on up the spectrum from a person who has no contact in Georgia to a person who has a lot of contact in Georgia, then it's more likely that long-arm jurisdiction could be used to sue them here. So imagine for a second that Jake owns a bunch of car dealerships across the country. 2 of them are in Georgia. He owns a lake house in Georgia. He spends his entire summers here every year. He owns part of a business that owns some dry cleaners, and they have some businesses around Georgia. He can for sure be sued over anything that happens while he's here. He can for sure be sued here over anything related to the business he does here. But he's also opened himself up to be sued for things that might not be directly related to what he did because he has so many contacts with the state of Georgia. Because he's here so much, because of the volume of his activity here. The less you do here, the less likely you are to be sued unless it's related to your specific contacts here. The more you do here, the more contacts you have, the more likely it is that you can be sued, not just over what you did here, but maybe something else. That's the idea of long-arm jurisdiction. It evolved over time because the time that we wrote the Constitution, there was not much interstate commerce at all. Society wasn't mobile. People didn't go to another state for spring break, right? Their activity was pretty much limited geographically to their local area. So the idea 200 years ago of a person being sued in a state that they didn't live in, that was rare. And the idea of them being sued in a state they didn't live in and had no contact with and had never done anything there was also rare. Not so today. especially in the context of business. So that brings us to, I'm skipping ahead in the outline for a second, to jurisdiction in cyberspace. How does long-arm jurisdiction apply to individuals and businesses who conduct business over the internet? Just about like you would think. Wherever you are reaching out and doing business, even if it's from your living room, the more likely you are to be subject to jurisdiction in another state or another country based on your activities, what you're doing there. We're going to read a case for Thursday's class called Arrow Toy Store versus Greaves. It's a Georgia case. And in that case, a Georgia resident bought a car, I think on eBay Motors, something similar, from a Florida company. Georgia guy never left the state to go buy this car. Florida company never left the state of Florida to sell this car. They negotiated, the listing was on eBay Motors. They negotiated via email. The seller shipped the car into Georgia, and then there was a problem with the car. So the buyer wants to sue the seller. The buyer would rather sue the seller in Georgia. It's more convenient for the buyer, right? The buyer might also think that the courts would be more friendly to him or her if they were able to sue the seller in their hometown, right? I'd much rather make an argument to a jury. This Florida shyster company is taking advantage of Georgia residents. I might get a jury here in Columbus to be more sympathetic to me than I would if I sued them in Florida. Could I go sue them in Florida? Sure. That's where their business is. That's where they do business. But I might rather do it here. So that, in that case, buyer sued the seller in Georgia, and the seller's defense was, you don't have jurisdiction over me. I'm not a Georgia resident. You can't have personal jurisdiction over me. And the buyer's response was, yes, we do, by using long-arm jurisdiction. This lawsuit has to do with your contacts, your activity with Georgia. I'm a Georgia customer. You reached out. You did business in Georgia. You shipped the car to Georgia. You sold to a Georgia resident. And so that case is about whether or not the Georgia court has jurisdiction over the Florida seller based on the activity that the Florida seller did here. So we'll read through that and talk about that more on Thursday. That's kind of how that works. So in the business context these days, we can, from our living room, hell, from our bed with our laptop, we can conduct business around the world. What that means for you is that you have to realize that you're exposing yourself, you're opening yourself up to being sued in all these other places that you're doing business. It doesn't mean it's automatic, but it means that you might have exposure to that. Certainly, if you're the seller or you have customers in another state that you've reached out to and you've advertised to, that you've sent marketing materials to, you've solicited business in other states, and then something goes wrong and there's a dispute about the business you did in another state, very likely you're going to be subject to jurisdiction if they sue you in another state. Similar to the rationale that we use in deciding whether it's fair to sue a non-resident out of state, same thing for business. So the more active the defendant is in the state, the more they send out emails, solicitations, marketing blasts, the more they post advertisements on social media that end up in your feed. That's the seller actively doing business in other states. over the internet. Contrast that for a second with, what if I just have a website that says Tebow Motors and a phone number on it? It doesn't show any inventory. It doesn't list anything for sale. It doesn't really even tell you what I do. You could guess that I'm in the automotive business based on the name, but you wouldn't know that. That might not open me up to jurisdiction in other states if I haven't proactively done anything to solicit business there. Usually a passive advertisement is not treated the same as an active business solicitation, if that makes sense. Same rationale. If you've done something in another state where it would be fair for you to be sued there, constitutional. Not so much if you haven't done anything in that other state or other jurisdiction. Now, you might also be thinking, well, what if I do business over the internet internationally and I get sued in Italy? Can they really do anything to me? Yes and no. If it's not criminal, then they're not going to ask this country to ship you to Italy. If it's criminal, they might could do that. And if they got a judgment against you in an Italian court, you might laugh and say, well, fine, I don't live there. How are you going to enforce that? There are ways to enforce foreign judgments, but they're pretty complicated, and they would involve the Italian person coming to this country and trying to use that judgment in a court here against you. I'm not testing you on that. We're not getting into that. Point being, it is harder for a foreign jurisdiction to get you, but they could. It's not impossible. So don't think that just because I'm doing business internationally, but I don't live there, that I'm insulated and I'm protected from legal consequences in another country. That's not necessarily the case. The law treats businesses like people when we're looking at residents. So a corporation obviously has to be incorporated in one state. And a business can be sued in any state in which it's incorporated, even if the only thing they did there was incorporate. But let's say, lots of businesses will incorporate in Delaware because of the way that business litigation has evolved in Delaware, again, way beyond our scope. Might be incorporated in Delaware, but they don't have an actual physical headquarters or businesses anywhere in Delaware. They could be sued where they're incorporated, and they can be sued in any place where they do business, where they have a business. So you'd be considered a resident of Alabama if you own a business that's incorporated there, or that's incorporated in Georgia, but you actually have a physical location in Alabama. You're an Alabama resident. Your business is considered an Alabama resident for jurisdictional purposes. Page 3 talks about cases that go to federal court versus state court, and I think I covered that last week, so I'm going to skip through that today. And we talked about jurisdiction in cyberspace, so I'm going to the top of page 5. A couple of legal concepts that I want you to know about. Venue is similar to jurisdiction, and venue gets confused with jurisdiction a lot. Jurisdiction, remember, is the power of a court to hear a case, either over the parties or the subject matter. Venue refers to the actual court that you're going to once you know what court system you're in. So venue is more synonymous with location. So let's say that I know that I'm going to be in the federal court system, that my case is going in the federal court system. Georgia has 3 federal court districts. Which is my venue? Which location do I go to? Let's say that your case involves a divorce. Divorces have to be in Superior Court in Georgia. All right, well, there's 159 different Superior Courts because we have 159 counties. So which one do I go to? Which one has venue? And it's normally the one where you live. Answer, I read your mind.
I thought it was a question.
Oh, you knew the answer. Gotcha. So that just means venue. You'll hear sometimes in movies or TV shows about change of venue. You're in the right court, you're in the right location, but one of the parties wants to move to a different geographic location because of publicity, or they don't think they can get a fair trial locally. Maybe something that the case has got so famous that the jury pool's been tainted or everybody's prejudged it. I don't know. Change of venue is not very common. The other concept is standing. So the idea of standing is that in order to file a lawsuit, in order to sue somebody, you've got to have a personal interest in the case. It has to affect you somehow. You have to show that the lawsuit has some effect on your person, your business, your land. Something about your interest is affected. So if Mr. Bola and I get into a car accident this morning and we both want to sue each other for injuries that we sustained, Mr. Janeway can't sue Mr. Bola or me related to that accident. He has no standing. He has no interest in that. If CSU fires me because I'm old, Daquan can't sue CSU for firing me because I'm old. He doesn't have standing. He doesn't have an interest in that. I sure do, but he doesn't. We don't confer standing on inanimate objects or animals. So like a tree can't sue a developer to keep them from cutting down a forest. A dog can't sue its owner. They don't have standing. People do, corporations do, entities do, governments do, but objects and animals do not. All right, within a state court system, how does a lawsuit proceed? So when we talk about litigation, that's everything that's wrapped up in lawsuits. The way a lawsuit begins is that the plaintiff, remember, plaintiff is a person who files the lawsuit, who does the suing, who brings the case against the defendant, the person against whom the case is brought, against whom the suit is filed. Plaintiff files a complaint with the court. Plaintiff's going to go through the exercise that we've done for the last 2 weeks. Where can I sue this defendant? What are my choices? Do I have any choices? I know I can sue the defendant where he lives. Am I suing him about something that happened in a place different than where he lives, that I might could sue him there? Do I have a choice of courts? Could I go to the federal court system or the state court system? If I know I'm in the state court system, is this a case that has to be brought in one type of court, or do I have a choice? So the plaintiff and his attorney will make that decision. Where are we going to sue the defendant? We're going to file a complaint in the court that we choose. A complaint is a document that sets out who the parties are, who the plaintiff is, where they live, who the defendant is, where they live, what the lawsuit is about, and tells the court anything else the court might need to know. It's very basic. It doesn't have to be all that detailed. It just has to give the court and the defendant an idea of what the lawsuit is about and assure the court that this is a case the court can hear, that the court has power to hear, that the court has jurisdiction over. Anytime somebody gets sued, they're entitled to be served with the complaint, personally served with the complaint. So that's when the sheriff shows up at your house, Alan, and serves you with a complaint, hands it to you. Some jurisdictions, they can tack it on your door or leave it with somebody in your household who's of age. Sheriffs always do that. There are also private process servers who are authorized by the courts to serve people. So like if I have somebody that I know is going to be difficult to pin down or that's hiding from me or that's going to be hard to serve for whatever reason, I might get a private process server. When I send it to the sheriff, I kind of just, the sheriff will do it on their own time and at their own pace. If I get a private process server, I can be like, hey, this person works here, they live here, you might need to wait out here on them. Here's their phone number, you can call. You know, it's just a little easier to get people served with a private process server. More costly, but sometimes more effective. So the defendant has the right to be served. Once the defendant is served, then the defendant files a document that we call an answer. All these documents that are filed with courts are grouped together in, they're called pleadings. Complaint is pleadings, an answer is pleadings, motions are pleadings, anything that gets filed is a pleading. So the answer will be a response to the complaint. It'll deny or admit certain facts, and it'll list out any defenses that the defendant has. So like in the case that you're reading for Thursday, in the Florida seller's answer to the lawsuit, one of the defenses that they list is jurisdiction. We're not subject to jurisdiction in Georgia because we're not a resident of Georgia. Of course, the court's going to sort that out. But any defenses you have, it wasn't me, I didn't do anything wrong, you don't have jurisdiction over me. There are a multitude of defenses that a defendant might assert, and the answer would be the place to do that. All right, once the answer is filed, and it's important if you ever get sued to file an answer. If you don't file an answer within the time period that's allotted, then you might default, which means you automatically lose without a chance to go to trial, without a chance to present evidence, without a chance to confront witnesses and that sort of thing. So very important, if you or your business or in the course of your employment, you receive service of process of a lawsuit, you need to answer it and get it to your lawyer or to your employer as soon as possible. There are rules about, we're not getting into them in this class, but there are rules about how to sue a business, because obviously a business is not a living person. So if I file a lawsuit against a business, how do I serve it on the business? And there are rules about, you have a choice, basically, of some people you can serve. Nothing you need to worry about for this class. So once the answer is filed, then a period begins in the litigation called discovery. This is a hugely important part of what you need to learn for business law, the discovery period. All right, this is when both sides can ask each other for information. And not just each other, but outside sources as well. Discovery, as a general rule, is very broad. Just because you ask for information in discovery, just because you collect or gather information in discovery, it doesn't mean that it's automatically going to be able to be used at trial. That's a decision the judge would have to make at the time of the trial if there's an objection to some evidence. But as long as we're in discovery, as long as it's relevant or indirectly relevant in some kind of way, the legal standard is it reasonably calculated to lead to the discovery of admissible evidence? In other words, is this likely to, is it likely to head somewhere where we might get something relevant? So it's very broad. I'll give you some examples in a minute. Discovery is conducted in a bunch of different ways. So I want you to be familiar with the tools of discovery. The first one is written interrogatories. So once discovery commences, either side can send a list of written questions for the other side to answer. And the other side has to answer them in writing under oath within a certain amount of time. I like to use, it's not a business case, but it's really easy for you to relate to conceptually. I like to talk about divorce when we're talking about discovery. So in a divorce case, the main business of the court is ending the marriage, but also dividing up the assets and debts that the couple has, right? So one of the main things that the court's going to need to know and that the parties are going to need to know is what is out there. What do we have? What do you have? What do I have? What do we have? So a basic set of interrogatories at the beginning of a divorce case might be a list of questions like this. Give me a list of every bank account that you own or that you own with somebody else. Name the institution, give me the account number, give me the date that you opened it, and tell me what you use it for. Okay, that'd be helpful for me as one of the lawyers for the parties to know. Give me a list of every business that you own an interest in. And for every business, tell me what your interest is. If you're an officer, tell me what your officer position is, how long you've been there. List for me every source of income that you have. Tell me how much you make from that every year. Those sort of things. I don't say this to be funny. I say this to maybe I'm saying it to scare you. But in a divorce case, interrogatories would include things like, give me a list of every social media account you have and your username, including dating sites, hookup sites. Give me a list of every person that you've had sex with besides your spouse during the marriage. And for every time, tell me when, where, and what you did. All that kind of stuff is discoverable. Okay, so if I'm representing a party in a divorce case, I'm asking all kind of questions in writing under oath, and I'm getting those answers back from the other side. I can also use the discovery tool of depositions. A deposition is a interview, a question and answer session between a lawyer and a witness or a party under oath, recorded by a court reporter. Anybody in here ever given a deposition? Good. They're uncomfortable as hell. Just picture a lawyer's conference room, court reporter sitting at one end of the table, your lawyer sitting next to you, opposing party on the other side of the table, and the opposing party's lawyer on the other side. You get put under oath, and then the opposing party's lawyer can ask you pretty much anything they want to ask you. It does have to be relevant or indirectly relevant, like I was talking about. So in a divorce case, I might want to depose, take the deposition of the spouse that I don't represent, right? If there are allegations of infidelity, I might want to take the deposition of the girlfriend or the boyfriend. If the other party owns a business, I might want to take a deposition of the CEO or the CFO or the bookkeeper, find out how they run their business. Where does he or she hide her money? Skipping out of the divorce context for a second and going to the business context. Let's say I get sued. Let's say that I get fired by CSU and I believe that it's age discrimination. And I sue CSU for that. My lawyer might want to depose probably Dean Kidder, who fired me. Probably Dr. Finley, who's my department head. Maybe any other professors who might know something about it. Just because you don't really know anything about what happened doesn't mean you can't be deposed. Because until I ask some witnesses, I might not know what they know or don't know. So depositions would be very useful. Depositions are also great because they are call and response. Like I can follow up my next question based on the answer that I got from the witness. I can also see their demeanor. I can hear their tone of voice. I can watch their body language. But most importantly, I can follow up and ask other questions based on the answers I'm getting back. Contrast that for a second with interrogatories. That's where I sent the list of written questions. All I got back was a list of written answers. I don't get to follow up on that. So very often what we'll do is we'll send interrogatories first and get a lot of the basic stuff out of the way so that we don't waste time at the deposition saying, list for me every account that you have. What account number is it? What bank is it with? When did you open it? That stuff can be answered in writing ahead of time. Then I get to the deposition and I can be like, all right, Mr. Bola, tell me about that SunTrust account you have, that Truist account. I want to know more about that. You also have to consider where you are more likely to get the information you're looking for. If I just invite Mr. Bola to a deposition and he comes and I say, tell me all of the accounts that places you have accounts. He might be like, ooh, well, I know I've got one at CB&T. I think I have one at Truist. I might be on an account with my dad at Bank of America. But if I've sent him that interrogatory ahead of time, then he's got time to look and research the answers and give me a comprehensive. He can't say, I don't know. He can find it out. He might be in the deposition and be like, oh, I just don't remember that. I'm not positive what that account number is sitting right here. So you're going to be smart about what you ask and when you ask it. You had a question.
Mostly about sworn statements.
Yep.
For the cases, how does that relate to the deposition?
So sworn statements, a deposition is sworn testimony. Interrogatories are answered under oath, meaning that when you get to trial, if you give a different answer as a witness under oath at trial than you gave in a previous time when you were under oath, that could be used to impeach you or destroy your credibility. So I might say at trial, Mr. Janeway, tell me your sources of income. And you might name one that you didn't bring up before. And I might say, well, I'm going to show you your deposition. You see on page 4 right here, I asked you that question and you didn't list that. You didn't give me that answer. So you're just lying before, you're hiding something. I mean, maybe you have a reason, maybe you don't, who knows. Maybe you said in your interrogatories, I've never been unfaithful to my wife. But then throughout discovery, I've found evidence that you have. And I can ask you at trial. Remember, you told me in your interrogatories under oath that you'd never been unfaithful. That's not true, was it? And I might be able to show that you're lying that way. Sworn statements, are you asking about like an affidavit or given to a police officer or?
Like the ones that are, like the initial questioning that somebody is given by a police officer where they write pretty much what they have to say about what happened, and then they ask relevant questions to that after they were.
So what you might tell a law enforcement officer or something, that's not necessarily sworn. It's unlikely to be sworn, in fact, because it's not done through the court system. So if the FBI were to come interview me one day at my office, I'm not necessarily under oath. I might write something. I mean, if I write a letter or if I do a business contract and I'm emailing somebody about that, that's not necessarily under oath. It could be used in court to show that I wrote it, but it's not the same as being sworn to under oath. I don't know if I answered your question.
The ones that I've seen were more on the military side of it. You read somebody their rights, and then you get their statement, ask some questions about it, and then they sign the rights waiver as well with it.
Gotcha. So yeah, if it's involving a waiver of rights or something, then we're asking in the military context, then that could have a different, that could have the effect of being under oath, being sworn. That could be used against you. Yeah. Mr. Johnson.
Is there a time limit on the deposition? Like a certain amount of time that you can be in?
There is not a time limit on a deposition, but they can't keep you endlessly. If you get to the end of the day and your lawyer has to go, or you've got to go pick up a kid from school or something, you can stop it and start it again at another time. So it's not like you can use it to just outweight somebody or put pressure on them or something like that. They usually don't last more than a couple of hours. It's certainly possible in a really complex case that you might need to do it over more than one day, but I've found that usually a couple hours is plenty. I usually know pretty much what I want to ask, and I'll cover what I need to cover. I might not, depending on my strategy, I might not ask everything that I could ask of a witness at a deposition. I might just need to get testimony on a certain fact or area, and I'm going to leave the rest for trial because I don't want to give them a preview of what my cross-examination would be like. Or I don't want to give them a chance to spend time fixing the problem that I point out with their testimony or their case. I mean, discovery is really about just gathering information. You don't want to do any gotcha type stuff at a deposition because then you've wasted, you'd rather do that kind of stuff at trial. All right, so interrogatories, depositions. The other discovery tool I want you to know about is a request for production of documents. That's when you get to send either the other party or a third party a request that they produce to you certain documents. So let's say that I sent interrogatories and I asked the other side to list every bank account that they have and bank account number. And then I take their deposition and I'm pretty comfortable that I know where all the accounts are. I could either send a request for production of documents to the other party saying, give me your bank statements, your phone records, your tax returns for this time period. Or I could just ask the bank directly, please give me the statements for the last 3 years from account number, whatever it is. Whatever I think is the fastest, most efficient way for me to get it, I'd really rather get it from the other party, faster and cheaper. But lots of times people will ask for, like, give me every bank statement for everything you have, and then what I'll get back from the other side is half of what I was looking for. And I could go back and say, give it back to me again, or go to the judge and say, Judge, I asked for these bank statements. They didn't give me all of them. And the judge will say, give them all the bank statements, or I could just get them from the bank. So sometimes I might just want to do that. Your business and in the scope of your employment, you might get requests for production of documents for a lawsuit that you're not involved with. You still got to respond to them. So, brings me to my next point, and this is to kind of scare you, but I want you to think about, in the employment context, within the scope of your employment, if there is a lawsuit where the parties turn around and ask you or your employer for things like all your emails, your phone records from your business, your browser search history, any notes that you have. I mean, those things are discoverable in a lawsuit. And I'm being funny when I say I'd say that to scare you. What I really want you to take away from that is that everything that you produce in writing, work product wise, stuff you say that's recorded, all that might be discoverable in a lawsuit. And there's no way for us to predict what a lawsuit's going to be about. Sometimes we have a pretty good idea if something happens. Oh, somebody's getting sued over that, right? But most of the time, we don't have a crystal ball. We can't travel to the future and figure out what somebody else is going to want to sue us for. And so we can't spend all of our time at work writing an email worried about how this is going to look through the lens of something in the future. But we can be careful in what we write if part of us thinks, I might not want to write that. Might not be a good idea for me to write that. This is what I'm doing is discoverable. So I want to make sure that I do it in a way that's not going to reflect poorly on me or my employer in the future. Another thing that you can't ever predict is how something's going to look. You don't know what the context of the lawsuit is going to be. And so I have a client that is a state agency. It's the health department, not in Columbus, but in LaGrange. And I advise them on employment law related stuff. So one of the main things that I counsel them on is whenever we write up employee discipline, whenever we make decisions about, are we going to do a reprimand? Are we going to demote this person? Are we going to fire this person? I want us to be consistent with the policy, obviously with the law, but with decisions that we make in other similar areas, okay? Because that's the best way to protect yourself in future litigation, is to be consistent and clear and accurate with what you write and what you document and what you produce. sometimes they might call up and say, hey, we've got an opening for this position. We already know who we want to hire. Can we just go ahead and hire that person and not post this position? And my answer is no, because even though we know who we want to hire, we know who's probably going to get the job, later on there may be a lawsuit, and they may say, well, you don't always post jobs that you're supposed to post, do you? And we might say, well, it's our policy to post open jobs. But you don't. You didn't for this job. You didn't for this job. And we'd have to say, yeah, you're right, we didn't. When they want to cut a corner or make an exception, oh my gosh, I do. I want to make exceptions all the time. But that's the kind of stuff that can make you look inconsistent and not credible through the context, through the lens of future, of looking back. So it's better, in my opinion, to do things the same way, use the same decision-making process, be consistent with whatever policies you have. If you say you're going to post a job, post it. If you say you're going to interview people, interview people. If you say you're going to pick the most qualified person or the person that scores the highest on the aptitude test, pick the person who scores the highest on the interviews and aptitude test. Because in future lawsuits, if you're inconsistent, then that can make you look bad, even when you hadn't done anything wrong. Same thing goes for your business communications. Let's say that I'm negotiating a contract and I'm emailing my counterpart at the other company. It's a sales contract. And then later on, we're going to have a dispute about it, about the terms of our deal. If I've sent emails that are unclear or ambiguous or say things like, we'll work that part out later. Or, yeah, I'll give you a fair deal. Or, don't worry about that. Whatever you say is fine. Okay, that's going to come out in discovery, and that's going to undermine my position or hurt me in the lawsuit. So everything we do is discoverable. That's really your main takeaway from today. In a lawsuit, everything we do within the scope of our employment somehow is discoverable. Even if it's something that we didn't write, that we just said, they might say, well, Mr. Johnson, you worked right next to Mr. Tebow. How many times did you hear him sexually harass another employee? And you might say, ooh, every day. Well, I might want to take your deposition. I want you to tell me about all the things you heard. So it's not just writing, it's things you say too. So again, don't say that to scare you. I'd say that because I want you to appreciate that all this stuff is fair game in a lawsuit down the road. Now, don't go home and tell your spouses or your girlfriends or boyfriends that today in business law you learn how to win the lawsuit against them if something ever goes wrong. The other tip I'll give y'all, I want to talk about alternative dispute resolution. Well, I got a little more time. I'll start it. I won't finish it today. The other tip I'll give y'all is back when I used to do a lot of divorce cases and that kind of stuff, you know what one of the biggest sources of evidence that we had was? What do you guess it is? Right. Texts. Yep, that's one of them. Anything on your phone. Facebook. Don't post your business on Facebook. You'd be, I mean, the amount of, I don't know how to say this and not be in trouble because it's going to be posted on YouTube. The amount of naked pictures that I have seen from divorce cases is more than I burned in my memory in a way that I wish I'd never had. Especially, anybody in here military? You were, right, Gio? I swear, I tell people all the time, Soldiers, stop sending pictures of your junk. All the time. It's like they get in the Army and you think, I'm going to send out pictures of myself. That's what I'm going to do as a soldier. But that goes for everybody. That stuff stays around, believe me. And it's never been more embarrassed than if you have strangers looking at your personal pictures. All right, alternative dispute resolution. Litigation is costly. You have time off work. You have time spent defending a lawsuit or even bringing a lawsuit that you could be spending on other things. Your lawyer bills are certainly a huge part of the expense. It's inefficient. If Kim and I have a contract dispute and I sue her over it, we're not going to court next week. I'm going to file a complaint. I'm going to have it served on her. We're going to do 6 months of discovery. Our lawyers may file other motions. We may not get to trial for a couple of years. That's really not helping me resolve my dispute. So litigation is not a last resort, but that's what we do when we can't settle our dispute any other way. We have to sue each other. Once a lawsuit starts, there are ways to settle the case other than going all the way through the litigation process and going to a trial. This has exploded in popularity and use over the last 30 years. People realize that litigation is inefficient and costly and it's not the best way to go about this. So other ways of resolving disputes have come up. One way that's very prevalent, this isn't necessarily new. This has been around since the beginning of time. But one tool of alternative dispute resolution is negotiation. There's nothing stopping lawyers or parties from picking up the phone and calling the other side and asking them what it is they want or what it is they'll accept or making an offer. It can happen before a lawsuit starts. I might have somebody come to me who slipped and fell in the Target and they want to sue Target and they bring me the video of they've got all this great evidence. There's nothing stopping me from calling up Target and saying, hey, I've got a client who was injured in your store. Here's the evidence we have. She needs $8,000 to cover her medical bills. Is that something y'all are willing to pay? They might say yes. Businesses often do. So when individuals sue, get involved in litigation, we want to be compensated for our injuries, for our losses. But we also have a sense of we want justice to be done. We want this person to pay for what they've done. We want to win, whatever our motivations may be. Businesses who get sued, smart businesses who get sued, want to get out of it as fast and as cheaply as possible. So it might be that the business hasn't done anything wrong, but they get sued for a slip and fall and they want to settle the case for $5,000 and not have to spend $100,000 on legal fees or risk a jury giving some crazy award. So negotiation is always something that happens between the sides. Well, I shouldn't say always. I mean, you're not required to, but it's very, very common for one side to either pick up the phone or write a letter or an email saying, hey, we'll settle the case for this. Negotiations are not admissible in court. So I would never make an offer if I thought that at court they were going to be like, well, Michael, you offered $100,000 beginning of the case. So you must agree that you're at fault in this, right? Or you must admit that you want to pay something for it. Negotiations are not admissible. So that frees parties up to make offers back and forth, and you don't have to worry that it's going to be used against you. Negotiations, I mentioned, they could happen before a lawsuit starts. I think that any good lawyer, once a lawsuit does start, should pick up the phone and say, what is it y'all want? Because how am I going to advise my client on what their possible options are if I don't know what it would take to settle the case? I got to know what we're measuring it up against. If I pick up the phone and say, what do y'all want? And they say, we want $80 million. Then I can tell my client, we're pretty much going to have to go to trial. I mean, that's ridiculous. You don't have $80 million, we're not paying $80 million, it's not an $80 million case. But if they tell me we want $8,000, then I might tell my client, I know you haven't done anything wrong, but I can't promise you that a jury would agree with that. There's a couple bad facts in here for us. There's some things that aren't going to look great. $8,000 is a lot better than I think you could do. Or wouldn't you rather pay the $8,000 and know that that's all you're going to have than risk going to trial and getting dinged for $800,000? So until you know what your options are, you can't really weigh them effectively. I have found that negotiation really, really ramps up right before trial or right at trial. Okay, because lawyers can posture and bluff and stonewall and delay as a strategy. But then when it gets time to where the witness or the party actually is going to walk through the doors of that courtroom and have to get on the witness stand, people's courage gets a lot less. Especially I found that in divorce cases. We're actually going to have to go in there and answer these questions and look at these. Lawyers got pictures of what I sent. You know, I can be real brave up until trial and say, bring it on. But once the trial comes, I might change my negotiating strategy. Also, during trial, something bad may come out, or a witness might not do as well as you thought, or they might have a piece of information that you were surprised about. You can always call time out and be like, Judge, can we have a minute? Maybe the jury's deliberating and you're like, that went really poorly. Hey, prosecutor, you know when you offered us that 10 years in prison, is that offer still available? Might be willing to take that. So negotiation is a way to resolve a dispute without letting the court make the decision. And it can happen at any point. Thursday, we're going to talk about other forms of alternative dispute resolution. I've got examples of pleadings posted to your content module. We're going to walk through those and look at those a little bit. And then we're going to discuss the case of Arrow Toy Store versus Greaves. So that's what you need to read for Thursday. See y'all Thursday.